thank you for joining us for another episode of God, Law, and Liberty with David Fowler, President of the Family Action Council of Tennessee. Every week, we are putting culture, politics, and law on a collision course with the truth of God's Word. And now, here's David.
Thank you for joining me for today's episode of God, Law, and Liberty. And I think this is going to be, I hope, very helpful to all of you with respect to understanding really what's going on in the Christian legal advocacy community that really has accepted, I think unwittingly, a relativistic view or model of law. And you may recall last week I spoke about the friend of the court brief that was filed by the prestigious Ethics and Public Policy Council in Washington, D.C. It's filed with the Supreme Court of the United States, and it was in defense of Tennessee's law prohibiting medical interventions to treat a child's gender dysphoria. And the more I thought about it this last week, and the more I thought about the briefs filed by explicitly Christian organizations on how the Equal Protection Clause should be interpreted, the more I realized how little difference there really is between the EPPC's philosophic, enlightenment-based legal argument and that of these other Christian organizations. And I believe we have a real problem with that because the way Christian organizations think about the law really suffers from the same problem the EPPC's enlightenment-based brief faces, and that I noted last week. And what I want to do is to explain today why I think the present course being pursued by Christian legal advocates is so problematic and really unhelpful in the long run. And if there's a time, explain how common law properly used overcomes those problems. But knowing myself, we may not get to that latter part. But I do want to get to how common law helps address the problems I talked about last week and I'm going to be talking about this week, because I got an email this week from a law student. And it was really refreshing to see him thinking through what I was sharing with him about common law and to see all the great questions that were churning in his mind about how all this works and what we've lost. And I sure hope that happens some on this podcast. So anyway, to help us think through why there's, in my view, little difference between the Enlightenment thinkers and the Christian legal advocates, I want us to examine some of what James McClellan wrote in his book, Joseph's Story and the United States Constitution, about natural law. Now, the reason natural law came to mind, several reasons. One, every time I talk about common law to a group, somebody brings up natural law and whether natural law is the same thing as common law or how do they relate. But also, really, natural law is what EPPC is asserting in its brief without saying so directly. But also because a former state legislator and lawyer friend of mine in the Midwest, he works among state legislators in his state. He asked me a question about natural law after he attended a recent Federalist Society annual meeting. And he said one of the speakers addressed natural law, and that after his speech, he said, wow, the way people came up and were reacting to him, it was like he was a rock star or something. And he wanted to know what I thought about natural law, because so many Christians were so excited about what they were hearing from this speaker. And they think natural law is Christian. And you may think the same thing too, but let me sort of disabuse that notion, at least in terms of how natural law is understood today. And what I did is I shared with this friend of mine, this colleague, some quotes from McClellan's book about two kinds of natural law. And what I want to do is look at those quotes and then explain that since he's written that book, everything has changed that really bears on our view of law and the kinds of arguments we're making and whether they're effective. So here's what he writes about natural law. Quote, "At the risk of oversimplification, it may be said that throughout Western history, two hostile traditions of natural law are evident. The older and once dominant traditional natural law, encompassing the classical and Christian schools." And see, that's really what was being discussed and advocated at the Federalist Society meeting in the EPPC brief. He says, "The classical and the Christian school, quote, subscribe to the view that a divine being, ruler of the universe through an eternal and universal law, is the supreme lawgiver, and that natural law is an emanation of God. The ancients," you remember I mentioned last week, the EPPC brief was citing Plato and Aristotle, "the schoolmen," which would be the Catholic Aristotelian Thomistic type thinkers, the English legalist, and Richard Hooker all recognized, as Cicero put it, which goes back to before Christ, that God is the framer and proposer of this law. And I remember loving this when I first read it in this book 20-something years ago. I remember loving it when I first read what Cicero said that was in Russell Kirk's book, The Roots of American Order, about this natural law. And it's what is being said here is an accurate historical assessment. But I'm going to show you what's changed in the world that really makes this idea of natural law unhelpful, particularly when presented to the United States Supreme Court as a legal argument. And so then McClellan describes the other tradition, and here's what he says. "Modern natural law theories are built around the doctrine of a state of nature," which, as you might guess, represents their version of the creation story. This was, as McClellan correctly notes, the first attempt to construct a lay or secularist theory of ethics and politics. And here's McClellan's summation of the natural law theories. Quote, "The state of nature concept used by Hobbes and later modern natural law thinkers, think about John Locke, for example, Jean-Jacques Rousseau, was a distortion of Christian theology." And this is what's important about the Christian theology they distorted. The Christian theology, McClellan says, had, quote, "subdivided nature into pure and fallen, or perfect and imperfect." And notice this is not a division of the world according to nature and grace, which is a kind of dualism that's unbiblical. It puts the place of antithesis in this world in the wrong place, as between nature and grace rather than sin and righteousness. But anyway, McClellan continues, "Hobbes abandoned those subdivisions, denied the importance of the fall, and accordingly asserted that what is needed for remedying the state of nature is not divine grace. See, that would fix the problem between sin and righteousness, the ethical problem we have. But we need the right kind of human government. Moreover, McClellan says, this reconstituted state of nature now became the starting point of natural law speculation. Highly individualistic, which you may recall is not the Calvinist theology that Harold Berman said contributed to the Western legal tradition. This highly individualistic modern school rejected the divine origin of natural law, exalted the autonomy of human reason, and exhorted man to look for a law of nature in a secularized state of nature. In other words, one devoid of God. Now I want to pause here for us to think about McClellan's statement that the new view of law was, one, highly individualistic, and secondly, it exalted the autonomy of human reason. And I want us to note a couple of things here. I want to begin with this exaltation of human reason, because that really pertains particularly to the EPPC brief. And this exaltation of human reasoning was a humanistic outworking and application of Descartes' attempt to formulate an epistemology that was then an ecclesiastical interpretation of Scripture. You know, the Catholic Church said, this is the truth, and then we had the Reformers coming along, sola scriptura, that no, the Scripture is the truth. And so who's right, the Catholic Church or the Reformers? And so he's trying to figure out, how do we know things independent of these battles between these ecclesiastical interpretations of what the truth is, right? And the answer that he came up with was expressed by, I think, therefore I am. And unfortunately, that proposition was used by philosophers to lead to reason having an authority independent of revelation. And that's where we get into natural theology, right? And eventually it led to revelation being subjected to human reasoning, putting God, rather than man and his reasoning, in the dock, as C.S. Lewis would have said. So this is a major shift in thinking in the West, and it would have the modern jurist today saying to the EPPC, well, why should I listen to the reasoning of Plato or Aristotle any more than I'd listen to the reasoning of more modern philosophers like Derrida, who concluded that things only have the meaning we give them. If all we can come up with is a God is not much more than an idea in our heads or an abstraction or a postulate for reasoning, that's not a real God. So that's really what I was saying last week, and I've talked about it in the past, referencing Roland Van Zant's book, The Metaphysical Foundations of American History. And I want to turn to that for a minute, because I think it's really helpful in understanding what's gone on in the world that's changed the relevance of any kind of natural law thinking and influenced the way even Christians now think about law. And if you want a transcript of of these quotes from Van Zant, just send me an email to senatorfowler94@gmail.com, and I'll get it to you. Anyway, he writes, quote, while man does have an outside world that exists independently of his conceptions, in other words, there are real trees out there. I don't imagine I'm seeing trees, right? That world can neither be known nor arranged, except in terms of an enveloping conceptual world of man's own creation. And you see, this is the fruit of Kant and his subdivision in knowledge between the noumenal world and the phenomenal world, or what we might say in theological terms, between nature and grace, which is a non-biblical dualism that's rampant in evangelical thinking. But we won't have time to get into that today. So Van Zant continues, the validity of man's conceptions, therefore, does not reside, according to the traditional dualistic philosophy, in an accurate representation of idea and fact, the matching of theory and thing. Now, what is he saying here? Let me repeat it just one more time and then I'll explain it. The validity of man's conceptions about things, what we think is true, does not reside, according to the traditional dualistic philosophy, in an accurate representation of idea and fact, the matching of theory and thing. And in other words, he's saying Christian theologians like R.C. Sproul would say that truth is that which corresponds to reality. You got to live within reality. So truth is what corresponds to reality. And he's saying, no. That's a theory where you're matching the theory of things to things. And we don't accept that theory anymore. And of course, that's exactly the kind of the world that EPC lives in, and the Christian legal advocates still assume that is out there and people believe in it. But Van Zant is saying, on behalf of all the modernist philosophers, no, that idea of the world and how we understand what reality is now discredited. And he says that in his very next sentence. There can be no, quote, pragmatic test on this basis, referring, of course, to the correspondence between what we think is true about the world and the facts of the world. The truth corresponds to reality kind of test. And I think what he means is this, and I think he'd agree with this statement, that absent divine revelation, which, by the way, is now subject to man's reasoning. Knowledge about the true nature of something, its meaning and its purpose, beyond how it can be used or manipulated or rearranged, well, that's just beyond us. And so the correspondence to reality conception of truth that the EPPC, I think, and many Christians would rely on, well, that's just another pragmatic attempt to explain things according to the prevailing philosophy of the day. Now, he notes this is a medieval conception of the universe, and that's true. But it's precisely this conception that the modern man believes science has discredited. Or in the words of Carl Becker, the historian that I quoted last week, quote, "We've seen further into things than we've ever seen before. The more attentively the physicist looks at the material stuff of the world, the less there is to see. Under his expert treatment, the substantial world, the world of things, in other words, of Newtonian physics, has been dissolved into a complex of radiant energies." Now, of course, Becker and these modernists don't want to go back and reconsider the postulate that there may be a God, but having seen that the world doesn't work like the machine we thought it was, and the substances don't appear as what we thought they were, well, now everything is sort of up to grabs. So with the supernatural no longer knowable to us by reason, and the natural world having aspects of it that don't accord with what our reason would expect, we come to what Van Zandt writes next about what constitutes truth, so to speak. And here's what he says. The validity of man's conceptions, in other words, the validity of our truth claims, depends on whether, in terms of his closed world of enveloping concepts, in other words, the world envelops us with all these facts and these things that are out here. The factual world that he has made known and ordered within that world continues to work as its own self-contained harmony. Now, that's a gobbledygook, and let me repeat it again without me interrupting myself, and I'll explain it. But he says the validity of man's conceptions depends on whether, in terms of his closed world of enveloping concepts, the factual world that he has made known, like through science, we've made certain things known, and the way he's ordered it within that world continues to work with its own self-contained harmony. So we have to figure out how to put all these pieces together to create a harmony, because there's no God who has created a harmony. He continues, the pragmatic test of does everything seem to harmonize doesn't refer to the harmony of man's ideas as against the objective world that exists outside those ideas. You see, so here again, he's discrediting the correspondence to reality test of the Christian philosophers. This pragmatic test doesn't refer to this kind of harmony. Rather, it refers to the successful ordering of that outside world within the enveloping world of man's own conceptual symbolism. See, we don't really know the nature of anything, really. We just have a bunch of facts, and we have to figure out how to fit them together as best we can to harmonize things. And so really everything is reduced to a symbol. Our system is symbolic. It's not really true. In other words, symbols only represent something, but they don't tell us anything about the thing itself, which is why words change in meaning. They no longer represent or symbolize what they used to mean. The practical example is in transgenderism. The dress is not a symbol of what it means to be a woman, because a man can wear a dress, right? Dresses are not, in our culture, a given and accepted symbol of what it means to be a man and a woman. So we have to have a new conception of ordering our outside world to now harmonize with our new ideas about what it means to be human. You see, that's what's going on. And it's really analogous to why I've spoken about metaphors on my podcast, and why we did a Chalk Knox Unplugged show in Nashville entitled A World Ends When Its Metaphor Dies. You can find that on our podcast website here. But this is what's really happened. The Christian world has ended, friends. the Christian metaphor of Christ being the person through whom all things not only exist but are to be understood, well, that's dead. At least in the minds of the influential, the thinkers, the leaders of our institutions. And to be honest, based on the sermons I've heard most of my life, I'm not sure I ever heard of Christ being spoken of in those terms, as being the representation, the metaphor through which we understand the world, even though the Scripture presents him in those terms with the word image. Christ is the image of God, from which we get our word icons. And so we see this end of the Christian view of the world in Van Zyck's next statement. Here's what he says. This world does not, quote, go wrong as a faulty picture of what is assumed to exist outside it. In other words, things don't go wrong because of God and his judgments. No, that's not believable anymore. Instead, here's what he says. The modern philosopher and the modern natural law thinker would say things go wrong because we have, quote, an inadequate formalization of that larger world that exists within and around it. In other words, as we discover new things, as development continues, our picture's just too small, and so we have to cast it aside and come up with a new formula. We just need a new formula. That's all we need. But this is interesting. Here's what he says about what these formulations do. Through this formalization, which becomes institutionalized as man's society, all men, individually and collectively, constantly enhance their power through the organized control of the very structure of the natural universe. And so, whatever the facts of the outer world might be, they have no significance or meaning for man until they are successfully symbolized in terms of the world of concepts that he himself has invented. Man has become God. And this view, this is what's fascinating, see, he says it eventually becomes institutionalized, and all men are sucked into it. The importance of institutions, which is contrary to this exaltation, right, of the individualistic world. But anyway, I don't need to go down that rabbit trail for right now. But you see, we still come back in this last quote that things have no meaning until we've successfully symbolized them in terms of the world of concepts that we've invented. And we're coming back to symbols, images, and metaphors that help us hold our understanding of the world together. And this power over nature that Van Zandt describes is precisely what C.S. Lewis said it would be, the abolition of man. So let me wrap up this little segue from McClellan and modern natural law thinkers to say that this is where we've come to. There no longer is any classical school of natural law, as EPPC would wish, except historically there was such a thing. But there isn't any such thing now that has meaning because of the formulation of the world, as it was understood at the time of those philosophers that they referenced, Plato and Aristotle, is a formulation that no longer works. It no longer holds things together in our time, and the way things are being presented to us now in our time, see? And of course, the Supreme Court can hold on to this old philosophic conception if it chooses to. But I hope we see that we've not won, even though this particular trans law might be upheld. Rather, we've lost, because we're still saying that all law is seen as philosophic. It's not believed to be rooted in any enduring thing. It's not rooted in a correspondence to reality kind of truth. It's not rooted in creation. So we've just argued according to the modern natural law theories and further reinforced them, in my view. And the second thing that I think we should consider from McClellan's last statement that I quoted about the state of nature is that it's highly individualized. Because this was a result, too, of the departure from the Christian understanding of the true state of nature we find in Genesis. And I can see I'm not going to get to that today. But just as a teaser for next week, because we need to come back and look at this observation by McClellan that I've seen in Christian briefs is why the Christian briefs I've been reading come to the same problem that the EPPC has. And here's the teaser for next week, and then I'll wrap up. This individualized conception of the world is the repudiation of the Calvinistic conception of the world that Harold Berman said last week, quote, had profound effects upon the development of Western law, especially in England and America. And we need to look at that and why that was lost and what happened in evangelicalism that lost that undermined, to be honest, the Western legal tradition and our views about law. But let me wrap up here today by drawing a line from the EPPC brief to the ones filed by Christian legal advocates that address the interpretation of the Equal Protection Clause. Because I want you to see why I think the difference between the two is insignificant, really. And demonstrative of what I see as the problem in Christian legal advocacy today that puts the Christian legal arguments in the same posture as that of the EPPC is found in a meme that was put out by Alliance Defending Freedom about its brief. I'm not picking on them. I'm just using it as demonstrative of what I think's going on. And here's what it said about their brief. Quote, Tennessee has a right to regulate medicine consistent with biological reality and protect children from experimental medical conditions. Now, that's a fine soundbite. People say, yeah, they ought to have the right to do that. But, this right to regulate is exactly the same kind of thing we argued for 50 years about abortion. Not that it's just wrong and that substantive law would say it is wrong everywhere. No, we ought to have the right to regulate, consistent with our understanding of biological reality and what it means to be human and motherhood and all those things. See, so I think this statement really rests on a belief that at best the Constitution provides for an allocation of lawmaking power, but it seems to have nothing to say about the law substantively speaking. But I think those who know our common law history and that it provides the grid for interpreting the Constitution's words and phrases. Cicero and Plato don't provide the grid. Common law provides the legal grid. They would say, more than the state has a right to protect children, they would say, as my brief did, that states have a constitutional duty to protect children from the intentional infliction of injuries to their otherwise healthy bodies by third parties. And they would say that because they believe, as I do, that there's something universally true about what it means to be human, and it doesn't vary from state to state. And to be honest, the classical natural law view would say the same thing. But as I hope I've made clear, it is a philosophy being argued, not law. But those who make a legal argument to the effect that states are free to recognize the truth, but it isn't a universally true truth about what it means to be human, and California could have the same thing, a different view, they have actually adopted a relativistic view of law. The law can vary depending on what the reasoning, individualized man might, and in conjunction with other men, might think. This is how we should conceptualize the world. Protect children. No, we conceptualize the world this way. But it's not a declaration, you see, that any kind of reasoning is for sure true. Just this is your conceptualization of the facts, your formulation according to your pragmatic test, but it's only true in your state. So do you see how, in a sense, they really end up in the same place as the EPPC? And it leads me to McClellan's last observation about the new modernist, the new natural law. And I really hope this ties things together today. Speaking of this new modern law, it says, conceived in the mind of man and devoid of theological or historical foundation, the state of nature necessarily varied according to the excogitative genius of each philosopher, what they came up with out of their heads, right? He might imagine it nasty, brutish, and short, which is, of course, how Hobbes described the state of nature, or he might imagine it peaceful and pleasant. Thus was the way prepared for a relativistic law of nature, which rested on the shifting sands of a totally subjective model, meaning man-focused model, not an objective God-focused model. That's my addition to what he said. But if you'll note here, McClellan did say that this new modern law was devoid of theological or historical foundation. But I hope we've seen from what Van Zandt has written, and I've quoted, that this historical foundation means nothing anymore. That's the point Becker's making as the leading historian in the early 1900s. History means nothing except that's what happened. So in essence, today we can have a theological foundation for law, or we can have nothing. There is no longer any middle ground, except maybe the Christian arguing that, well, states can choose to protect minors from sterilization, but the Constitution doesn't really say anything about whether states should, and so we can and you can't. But look, that's the same argument that justified slavery from state to state, and it's now justifying abortion from state to state. Is that really the best we can do as Christians? And I personally believe one of two things may be going on here. I hope I'm wrong. If there's a third, let me know. But perhaps many Christian legal and policy advocates just don't understand the kind of nihilistic void into which they're speaking. Because if they did, I think they would draft legislation and craft legal arguments in a way that would be directed to restoring what's been lost. But if you understand the void we're in, you would try to draft legislation in a way that would begin to bring back the law that we had. But here's the second possibility. They may just simply have no interest in speaking into that void. In which case, it seems to me they're simply trying to get 5 votes on the Supreme Court to win in the moment. But do we see that this is the pragmatic test of truth too? And in doing that, I believe, really, without maybe realizing it, they've accepted the idea that law can say nothing for sure about what it means to be human, and that meaning can vary according to the excogitative genius of the judges, legislators, and majority of people living in a state. And they're riding on the highway of a relativistic view of law and saying, that's okay by me. Tennessee has the right to say one thing about what it means to be human, and another state can say quite the opposite. And that's all the law can now say. That's the relativistic view of law being advocated by Christians. That's what McClellan was talking about. So I hope this has been helpful. But we can either get with God in Revelation, and we can get with the common law that had baked into it this cosmology and this fall of man, or we can just abandon it altogether and stick with this relativistic view of law. Well, thanks for joining me, and I'll look forward to being with you again next week.
If you enjoyed this episode, please subscribe to the podcast. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. God, Law, and Liberty is available on Apple Podcasts, Spotify, and wherever you listen to podcasts. For more information, please visit us at www.facttennessee.org. That's factennessee.org. And please follow us on Facebook, Twitter, and Instagram at Fact Tennessee.